may be little overlapping, Lordship, pardon me.
It is linguistic engineering for the word repeat.
Sorry, what?
In place of repeat, you are saying that there may be
Slight overlapping.
yes.
Overlapping could be, Lord, also the same word like repeat, but I said slight overlapping. So, Lord,
try to be precise.
I will take just
Yes.
15 to 20 minutes, for not
Yes.
more than that. Lord, we are deeply obliged also for Lordship's patient hearing, having regard to the fact that the Lordships are not dealing with one individual, Lord, the Lordships are dealing with the thousands of people, and then the Lordships have realized that and then giving us time. Because it's not a case of one individual, because it's a case of it's a case where public interest is also involved in a way, because Lord, public posts of 509 posts are being filled up, and the persons who are going to come and sit in those posts are going to be there doing the public bureaucracy or public duties for about 20 days, 20 years or 30 years. So therefore, Lord, the persons who should be picked up should be those who are actually entitled to be picked up. And then a person who is not otherwise entitled, Lord, cannot come and sit and be in a bureaucratic procedure, Lord, for about decades. Therefore, Lord, it's a case where Lordships would see, Lord, not in the perspective of a single person, Lord, but in a perspective of the state involvement is there, public involvement is there, and the role of the Public Service Commission is there. Not that Lordships are not available. I'm only trying to preface my case, not so to say that this has the ramification not just on the petitioners and the PSC, and it's a ramification having on thousands of aspirants as well as the public at large also. Lord, this reminds me of, Lord, before I take you, I have made the whole issues into three issues, Lord. One is, Lord, the technicalities. They have raised the technicalities. The other one is about GOMS number 29. The other one is GOMS number 96. That is physically handicapped. Two issues.
So GO 29 is under challenge in your petition?
Yes.
GO, in addition, you have challenged GO?
I have both issues, Lord. GO 29, that the procedure. GO 96, that is the statutory rule, physically handicapped. My item number is 94, my Lord. Let put number 32482. 32482 of 2024. So, my Lord, for the Lordship's convenience, my Lord, though there is a repetition and my Lord,
because what you have argued, you have already reduced it in writing.
I did.
You have given it to us.
No, not that, my Lord. Actually, my Lord, I tried to, because thereafter, my Lord, some new issues have been raised by them.
You only deal with those issues.
Therefore, my Lord, I Lordships can eschew the earlier one.
Yes.
Because I made a fresh one, my Lord, including their new attacks and all that, which will be useful for Lordships, subject to what Lordship is.
Yes.
My Lord, the first issue that, before I take you Lordships to the technicalities that they raised, my Lord, how they are not establishable. Sorry for that. My Lord. This is reminded me of, my Lord, five blind men, my Lord, trying to find out what the elephant is. All of us have different angles, my Lord, but finally it's elephant. Everybody wants someone touching the leg will say it's something like that. So all of us are saying the same thing, but my Lord, little differently, my Lord, which is the Lordships may have to bear with us. The other one, my Lord, the saying you Lordships always use, too many cooks spoils the broth. But I only wish, my Lord, too many of us will not confuse the Lordships. My Lord, only to make it concise, my Lord, I made it into three portions. That is, number one is technicalities, how they are not tenable. The second one is, my Lord, how GOMS number 29 is untenable and unconstitutional. And number three, my Lord, is how, my Lord, physically handicapped reservation is wrongly applied. Come, give me this.
Your petitioner is a physically handicapped person?
No, that's one of the grounds raised, my Lord, that we have to be physically handicapped. Why would we challenge if physically handicapped persons are in a beneficial position?
Therefore, one of the grounds.
I've dealt with that also.
That you are not a person agreed.
I am not, and I don't have to be.
Just only.
my lord, I made it, the first one, my lord, is written submissions on the issue of technical grounds.
Not only before that this matter was filed while the matters were being argued. In fact, none of us have filed that this writ petition 32482 that was filed subsequent to Millard, all these matters being.
When this is
We have never
filed,
filed a counter in this matter or
19th
anything.
November, this is filed.
after hearing commenced, no,
So,
before hearing.
Before, but
Before, but your lordship said since the hearing has commenced, it will be taken up, Lord, but
We-
we had specifically requested at the time, your lordship said that we are in any case, we need to bring your lordship's notice.
counter
We
and
didn't have opportunity to, not put anything in writing in Mr. Sudheer's case.
you file your counter.
Not in relation, huh? Sorry, sir.
Counter is there,
No,
Mr. Reddy.
my lord, my friends, they're expecting me not to argue because.
No, just a minute, PSC's counter is there. Mr. Reddy, your counter?
no, man.
Yes.
My
All right, we'll
counter is-
consider
Stand
it.
corrected.
I was only,
My friend filed a district counter.
That is PSC's counter.
Public Service Commission.
Yes.
Public Service Commission is the main hero in this plot because they are arguing.
Yes, we'll consider that, please.
And as a matter of fact, Lord, my friend has given me what has been challenged in the present writ petition in my case is nothing but Lord, what has been challenged in other cases. 29 and GOM.
Yes, we'll request you to be very precise.
Yes,
No repetition, please.
Yes, definitely. Lord, I cannot kindly take up the note, Lord, I have given.
Yes.
Lord, this is I don't want to read, Lord, I will only say, Lord, that number one is challenge after participation.
That
My
is
lord,
already
this
argued by,
approbate, reprobate, blowing horn.
already
My
argued.
lord, this has been mentioned.
Yes.
My lord, and then your lordships have also next page, Lord, this is precise for lordships also because this was argued by Mr. Sodhi also.
Yes,
My lord, Meeta Sai was brought lordships kind notice. Third point. I have given the extract also where Meeta Sai has
it is
considered.
just now read out
Yes,
before.
that's what I'm saying. I'm only running through. My lord, then Abhijit Sinha is also, my lord,
Yes, just now.
then,
read
Lord,
out.
no estoppel, Lord, I've given one more extra judgment, Lord, which says there can never be an estoppel against statute,
Yes.
Lord, that Krishna Rai's case. Because, Lord, the statute, Lord, they might say that statute, there is no statute here
Yes.
because we have a big statute, Lord, the Constitution. If there is anything, Lord, violative of Article 14, 16, fundamental rights, Lord, the lordships will not non-suit me for that. One aspect which has not been brought lordships kind notice is Ashok Kumar. Ashok Kumar is brought before lordships by them to say that hot and cold theory. But Ashok Kumar itself says, brought at para 19 I have extracted, they themselves stated, brought there is no patent or glaring illegality there. Last two lines.
Yes,
The very same judgment relied upon my friends categorically say that there is no illegality. On top of it, kindly also go to next page, brought page 4. Para 20 of Ashok Kumar says, no prejudice is caused to them in that particular case. So in the context of not having a glaring mistake and not having any prejudice being demonstrated, Lord Ashok Kumar said like that. So the reliance placed by Ashok Kumar has to be eschewed. And Lord, the other judgments categorically say the concept of approbate, reprobate would not arise. Lord, next, therefore, Lord, the lordships may eschew that argument. The second, Lord, page 4 is there is a delay. One of my friend also mentioned about the delay. In that context, I only have to add, Lord, which is not added by my friends. Lord, is that the GO 29 delay with regard to two aspects, GO 29 and GO 96. 96 is physically handicapped. Lord, GO 29 came on 8th February 24. And then, Lord, it was made public only on 11th, only on, Lord, 6th August 2024. Till that time, it was not made public, which is clear from, I mentioned at page 5. Lord, this was released, bullet number, last part 3. The uploaded file was created on 6/8/24, was named GOMS number so-and-so, so-and-so. But the number is mentioned, it is mentioned as 2024 refers to year, 8 refers to month, 6 refers to day, 17 refers to, so at 5 o'clock 32 minutes 43 seconds it was released on 6th of August. Well, that is at page 9, the screenshot.
yes.
Screenshot, you not kindly go to page 9 for a minute per mind. It was released only on
Yes.
No, when you keep your cards close to your chest and expect us to challenge, this is, you cannot raise that ground of delay. You should have released everything when the courts are saying, the recruitment process should be transparent, not opaque. And therefore, the concept of delay would not arise. Then, at page 6, I have taken a bullet saying that the question of delay will not arise in a matter where, the issues will go to the root of the matter. My case, is top bullet. My case is that the whole thing is, the whole thing is a fraud on constitution because reserved candidates and are not benefited and they are deprived, and it goes to the root of the matter. Therefore, the question of delay or technicalities will not come in the way, and the lordships will eschew all those technicalities. Then, second bullet, this is very important. Honorable Apex Court in the earlier round of litigation, set aside the whole thing after the examination is over. They had to reconduct the mains. I have mentioned that, second bullet. I find a copy of that also. I'll take your lordships that. So the question of, lordships would not be, shirking, and then the lordships will not non-suit us on the ground of delay. More so, when there is so much of issues are involved. And, Mr. Sondhi also has argued, though, Justice Karthik, which was delivered by the single judge, which is approved up to Supreme Court, has been rejected only on the ground of delay. But now the issues here are different. Issues here are different. The issues there are different. 29 was not subject matter there. Physically handicapped issue is not the subject matter there. But therefore, the one bench, which has gone up to Supreme Court, deciding about a particular, not deciding about these issues, deciding about other issues, lordships will not rely upon that because they are relying upon that because that is a different issue altogether. Whereas here, it goes to the root of the matter because it's a procedural issue. Now, second, delay with regard to, at page 6, delay with regard to 96, physically handicapped. Because 29 delay I have explained, because it was released only in August. And first writ petition was filed in August. First writ petition was filed in August. And therefore, subsequently, immediately when it is filed, and subsequently whether it is September, October, November, makes no difference because your lordships are hearing it as a batch. Now, second issue is about whether there is a delay with regard to challenge to physically handicapped issue. At page 6, that particular GO was issued, 96, regarding 96 GO, physically handicapped issue, was issued on 26/4, was issued earlier, and after the notification, earlier notifications, earlier both women and handicapped were treated as vertical, but insofar as women is concerned, that is taken away from the vertical concept, and then it was rosters were released, but they did not do so. And now, as a matter of fact, what is being challenged before lordships is a statutory rule. We will be coming to lordships only when it is hurting us, though it might be issued long back. We will come to lordships only when it is when it hurts.
It was issued 96 when it was issued.
96 was issued, in 2019.
Can you specific date?
Date, 22nd July 2019.
Yes.
That's a statutory rule.
Yes. How it is coming in your way?
No, that I'll explain, as to, I'm only talking about the delay. Then come to page 7, The third technical ground raised by them, which was not argued by my friends, is about, of course, slightly touched by my other friend, that instructions in the notification are paramount, as it can, they are the truth, biblical truth. But that was a judgment was also relied upon to say Tamil Nadu judgment, Tamil Nadu, state of Tamil Nadu versus Hemalata, which is there in the compilations, to say by my friend Manoj Rajshekhar argued, saying that instructions are paramount and they have to be given priority. But I am only trying to say your instructions cannot override the statutory mandate and the statute, and the judgment in Hemalata is with regard to instructions to the candidates. You should not write with pen, you don't scribble on that and all that. That's an issue, individual issue. if a person is rejected, if it's a person is, you are supposed to come at 10 o'clock, he comes at 11, that's your out the selection process. That's different. This is not selection procedure. That cannot be equated to a whole selection procedure where you are dealing with the whole selection. That one person going out of the selection is not unconstitutional. Therefore, that judgment relied upon by my friend to say that instructions have to be followed tooth and nail. It has to be followed like a biblical truth, is unacceptable. Then, Lord, my friend also argued that there are no averments challenging specific averments to 29. With respect to my friends, I think this is contrary to the record and a statement made without proper verification. Because I have given at page 8 how many paras I have utilized. As a matter of fact, it is more extensive. At page 8, para 4, item number 4 is the other technical issue raised by them, that there are no averments. Well, that's incorrect because kindly see paras 13 to 50 of by writ affidavit and 30 to 35. I mentioned both of them. With regard to 929, I mentioned.
Yes.
I mentioned about the paras with regard to 26. These are the technical grounds raised by my friends, and I'm obliged for that. In so far, I'm sorry,